there, Baby Lee. Hi, Dimples. Go ahead and start putting your questions in the comments, even though I'm going to start with a topic of interest first. But as soon as I finish, I want to just scroll through and answer your questions. Hello, it's so nice to see you. All right. So, today I want to talk about so let's start this way. Oh, well, I'm so glad that you scheduled time, Baby, and no need to be nervous. It's going to be a very comfortable process for you. That's we want all our clients to be comfortable, so don't be nervous. Everything will be fine. All right, so let's start with this. Okay, you have the 2-year green card already. Congratulations. Now it's approaching the expiration of that green card, and you have to now apply for the 10-year. So to go from the 2-year to the 10-year. The time to start applying is within 90 days of the expiration of that 2-year green card. You're with your spouse, and the requirement is you have to go from the 2-year to the 10-year jointly with your spouse. And no problem, you file with your spouse, everything is great, you're looking forward to getting that 10-year. And then about 6 months into the process, your spouse comes to you and says, I want a divorce. Um, you feel lost, right? And you don't know what to do next. I'm going to tell you what to do next. And the reason this topic is so important is because a lot of people make a big mistake when this happens to them. They think that there is no hope going forward without the spouse. So they give up. They don't follow up with the USCIS. They sometimes consider going back home, giving up their green card and going back home. They stay quiet and make the application process move forward with their spouse, and then they get called for an interview, and at the interview they can't show up with their spouse, so they get denied and they get referred to immigration court for deportation. These are the major mistakes that are made, and it doesn't have to be that way. You know what your reaction could be. I know it on the marriage side, it's devastating, right? Especially when they've blindsided you. Most times it's not a surprise. But in the case that you do feel blindsided and betrayed, I can understand that. But on the immigration side, there is no need to step back from your process or lose hope about getting your 10-year green card. As a matter of fact, once you've decided that you're going to move forward with the divorce, it's in your best interest to push forward and get that divorce done as soon as possible, because when you get that divorce decree, it's going to empower you to apply for a special waiver. You can apply before the divorce is finalized, by the way. But in order for immigration to finally approve your tenure, they need to see the final divorce decree. Now, the way that this works is once you know you can't apply with this spouse anymore because you're going to get divorced, then you push forward with getting the waiver done. You submit that updated waiver to immigration, letting them know your spouse is no longer involved, and you had a bona fide marriage. It's not it just didn't work out, and you can show the divorce decree or show proof that the divorce is moving forward. At that point, you can take control of your own 10-year green card process, and they won't be looking for any spouse to sign off on any documents or to come into the interview with you. Another thing to consider here is, what if you were mistreated, right? In the case where a spouse is, they're coming to you suddenly saying they want a divorce, usually it's not a surprise. Maybe there are some behaviors, a pattern of behavior that amounts to mistreatment. And if that's the case, you can also apply, even before your divorce is finalized, you can apply for a waiver based on extreme cruelty or abuse. So you have multiple options here. There's even a third waiver option for extreme hardship. Now, you do have to show that whatever extreme hardship has developed in the past 2 years that you had the 2 year, that if you don't get the 10-year green card, it's going to lead to an extreme hardship because of something, change in circumstances, some event that occurred over the past 2 years that will now lead to an extreme hardship if you lose your green card. So the point of this is you're going from the 2 year to the 10 year. Your spouse is somehow they can't be involved. It's not the end of the road. Don't give up. Don't not contact immigration, but contact immigration through an attorney. Make sure you do it right because you can't just call immigration and say, "Hey, I'm applying for the 10 year from the 2 year, but my spouse is no longer there." You have to submit a formal waiver, right? Along with your I-751. If you've already submitted your I-751, it's never too late to submit that waiver. But you must do it before they make a decision on your case. Because if you don't clearly state that you want a waiver, then they're going to deny it. And here's the really bad consequence that comes along with that is that if they deny your 2 year, the 10-year green card going from the 2 year, they will refer you to immigration court for deportation proceedings. So you definitely don't want to waste any time on this. I say it's urgent. And there was one very unfortunate situation that I found where I clearly advised an individual to get on it, get on the waiver, and they didn't. They didn't follow my advice. They didn't become my client. But then a year later, they called me and it was a lot nastier. They were in deportation proceedings. Our case was denied because this person did not, jump in and hire me and or hire an attorney, if not me, and qualified immigration attorney to handle the waiver. Could have been really simple. She did not do that, and so it went to immigration court. And at that point, it's a lot more expensive to deal with. And even then, it just became a very big expensive mess for this person. So make sure that you treat this with urgency and you invest in doing this correctly. For example, I had another client. As soon as she knew she was going to divorce, she contacted me. We did what we had to do, and she's a 10-year green card holder now, going on to get her citizenship. So it is very important that you not waste any time here. All right. So now that I've said my piece on going from the 2 year to the 10-year green card without your spouse, I'm going to go through some questions. So today I'm going to start on TikTok so I can, because I see a flood of questions coming in. So I'll start on TikTok and work my way around to Instagram. So bear with me as I make my way on each platform. Can I apply for I-751 late with a good reason? Yes, you can. And I say this, better late than never. As long as you're not issued a notice to appear in immigration court, you should apply for this because it means less. It's very likely that they will accept the case. Um, Master hearing 42B in February, visa entry toddler, son, citizen, mom, resident. So I'm not sure that is very jumbled. I'm sorry. You have to rephrase it. Can I have my I-130 petition submitted and work permit and do the green card later? No, you cannot get a work permit based on the I-130 petition. Get in touch with us. Let's talk about what you're trying to do here and what your goals are here. Because the I-130 petition alone is not going to get you the work permit. The work permit is based on the adjustment of status application that you're filing while being here in the US. Can I get a green card without me leaving the country? It's possible. I'd have to talk to you specifically to determine whether you qualify for that, but that's what we focus on here at the firm is helping people to stay here in the US and get their papers, their work permit and their green card. I got this message yesterday for I-130. Request for initial evidence was sent. What does that mean? It means they sent you an RFE. We call it a request for evidence. It could be anything. It could be something really simple like go do your medical, which is right now it's good news because it means that, well, the I-130, they don't ask for the medical. The I-130, that's for the I-485. The I-130 petition is usually based on the family relationship. So whenever you get a request for initial evidence, it can still mean that they just want some simple document that they don't have in the file that they need, or they may go as far as to ask you to show proof, more proof of the family relationship or the spousal relationship. How can I find you? Please go to the link in the profile. You'll see everything you need to get in touch with us. At the very top of this comment section on TikTok too, you'll also see the number. Give us a call. There's staff waiting to help you. Question, my son's green card got lost in the mail. Do I have to pay to get a next green card? It depends if it's the fault of immigration, like you gave them the correct address, but they still sent it to the wrong address. That means that immigration will not charge a fee. But if it went to the right address and somehow it just was not picked up, then they're gonna charge a fee. Can you speak on I-130 financial information? So there's no I-130 financial information. There's the affidavit of support that either is presented at the embassy or with the I-485. And that just means that when a petitioner is sponsoring an immigrant, they have to show the petitioner or a joint sponsor has to show that they make enough money to support the immigrant to come to the US. Good afternoon. Where can I find to answer that? All right. I did apply for TVs. I got my receipt and case number. But when I try to see case status online, it does not show my case because of confidentiality. So none of our clients' cases can show. Now they are implementing a process where you can call and ask about your case. So that may be something that you may want to try out now. Call the main customer service line. But we're very used to not being able to see the status updates. We usually only get updates by mail. Hi, good afternoon. Do you get a waiver when filing I-130 and I-485 together? No. So if you're talking about waiver of fees, if you are applying for I-751, well, not the I-75, if you're applying for adjustment of status based on VAWA, then there's no fee. So that would be one situation where you don't have to pay the fee. I filed for my husband over 6 months and nothing has been said to me. No letter. Did you get the receipt notice? It's not unusual to not hear from them for a while, but if you didn't get the receipt notice, that's where you should be concerned. Hello, good afternoon. All right. How long? How long does it take after doing a second medical for VAWA? Do you hear something? I'd say about 2 to 3 months. How long it's gonna take me to get a green card? It can range from 6 months to 20 years. It depends on who's sponsoring you. How long does it take to get a work permit after marriage? I'd say 3 to 6 months, as long as you file all the right documents. I submitted a green card marriage based in January of 2023 and then my RFE in February, and I still haven't gotten any updates since March. Is that normal? Yes, it can take up to 4 months to even hear something back, and sometimes it takes longer. It just depends on what they ask for and what the processing times are at that particular office. If your mom is a green card holder about to be a citizen, how long would over 21 child who overstayed get through? I'm glad that you brought this up, and I want to bring awareness to anybody who may have misconceptions about having a citizen parent. So, in this case, where you have a U.S. citizen parent, but you're 21 or over and you overstay, that means you don't maintain your status. It's going to take 5 to 7 years, but after those 5 to 7 years, they still won't allow you to stay here in the US to get your green card unless your parent, your citizen parent, can show extreme hardship on themselves based on you not getting your papers that would allow you to get this waiver, right? Forgiveness for your overstay. So you're looking at 5 to 7 years at minimum, plus the processing times for the waiver, and even after all of that, they will not let you stay here and get the green card unless they change the law. Let's hope they do. But for now, that's the rule. So you would have to still go back um, to your country once a waiver is approved and finish it out there, but at a minimum after 5 to 7 years. So, what I do in cases like this, I have been able to find alternatives. And so, I may be able to find one for you. So, schedule the appointment. Let's talk about your situation and circumstances, what you've been through while being here, and let's see if you have other options. Good morning. If someone filed VAWA and she called USIS to ask what is the delay on his case without his lawyer. Not sure what that. To always consult with your attorney. You should never uh, do anything behind the attorney's back or without the attorney giving their advice, because whatever you do could contradict the work of the attorney, and then it could actually mess up your case. So if you have an attorney, make sure you consult with your attorney before, doing anything on your own. I surely wouldn't appreciate it as an attorney representing my clients because of the complexity of their cases and because of the information that we have to provide. And if the client calls and there's something that I'm not aware of, then it can compromise their case. What if someone has stayed here for more than 5 years without any papers? What he do to change his status? So we look at multiple options, and there's no one way I can tell you right now because I don't know the facts involved. But this is where what we do in the consultation is we go through various options to determine if one fits the situation to be able to change status and get their legal papers here. So this is where the consultation is going to be very important. I have to depend on you to reach out and for help schedule that appointment so we can talk. When you apply for your T visa, can you apply for your travel document at the same time? No. You have to first be approved for the T and then apply for your travel document. Keep in mind, though, um, the travel document is not an entitlement under the T visa, right? So, this is why you don't get to apply for a travel document when you're applying for the T visa. As a matter of fact, a part of the application process is to show that you'll experience extreme hardship if you have to go back to your country. So, if you're applying for a travel document at the same time that you're saying that you can't go back to your country, it contradicts what you're saying. Because how are you applying for a travel document at the same time that you're applying for the T visa? Now, after you're approved for the T visa, you may want to not go home to your country, but you may want to visit somewhere else, or you may have business somewhere else, or you may have an emergency that you need to attend to. Keep in mind, this traveling back to your country does not go without risk when you have a T visa. But these are bases that you can apply for the T visa afterwards, after you get approved. But having a travel document on the T is not an entitlement. It's not something that you they are required to give to you, and sometimes it can lead them to question why is it how is it you're arguing two different things here. You want to travel to your country, but you can't travel to your country, right? So you have to take that into consideration. Has there ever been a cap on the T visa? No, surprisingly not. There are 5,000, and we've gotten a number of approvals for ourselves. We've never experienced a cap. I do anticipate with the changes that they're making that a cap may be reached soon. And in that case, in the changes to the T visa regulations, they have addressed deferred action, meaning that if they reach the cap, they're not going to deny you, but they're going to put you in deferred action where you'd still get your green card. You'd get not your green card, but your work permit, and be able to get permission here and protection from deportation while they wait for a place for you to be able to get a visa number and get your T visa. So we've never seen the cap, but if that happens, keep in mind that it doesn't mean you'll be denied. It means that you'll still get all you need to be able to stay here until you can get the permanent T visa. All right. Hi, good afternoon. Do you get waiver? Okay, I answered that. My friend is holding F1, and she had relationship with a guy who is still married, and the girl found out that he is married. Can the girl qualify to file for VAWA or the T visa? I don't want to straight up say no here. You do have to be married. So if say she got married and then she found out he was married at the same time, yeah, that's definitely VAWA if he's a U.S. citizen or a resident. But if she was never married and he ended up, having, having an affair, then uh, it's not VAWA because they were never married. However, we can look at the T visa, but it depends on the circumstances. Keep in mind, the T visa is not about mistreatment, in relationships. It's not about that. The central, um, the central aspect of the T visa is it's you can show that the immigrant, was the victim of a form of trafficking. Now, let me give you a scenario here that would fit within T visa. So, F1 visa holder met a guy who fraudulently promised marriage and told her to move in with him, which she did. Then he started to make her, restricted her from going to classes, told her that she should start doing work around the house, cleaning his house for him, making his food. He had unreasonable expectations of her. And then, in addition to that type of mistreatment, she also finds out that he is a married man. So he then starts to threaten her and starts to make her feel trapped in the situation, starts to say things like, when she finds out he's married and she says, I need to get out of here. Um, Furthermore, she didn't even sign up to do all of that work in the beginning, but now she's over it and she's like, I need to get out of this relationship. And then he starts to say things like, where are you gonna go? You know, if you leave, I'm gonna call immigration, or you're gonna get deported because you don't have anybody. Start to threaten to, if she doesn't do things to comply with him, that he's going to throw her out of the house and leave her homeless. Then that does amount to a form of trafficking. It can amount to labor trafficking because the whole goal was to fraudulently induce her into a situation where she didn't sign up for all of that, but he fraudulently promised marriage, had all these promises for her. And then when she got into the situation, found out he had other intentions for her. So that is labor trafficking by fraud because he forced her to do work that she didn't really want to do, but she felt like she had to do, or she could be out on the streets. And then if he also forced her to do other acts that she really didn't want to do, especially if she wanted to end the relationship, but he kept, told her, if you don't do this for me or that for me, I'm going to throw you out on the street, or I'm going to report you, or I'm going to straight up threaten violence against her, then that is also could amount to sex trafficking as well. So just keep in mind that there's more to the T visa than just, the mistreatment, emotional abuse by the spouse, the person you're in a relationship with, the intimate partner. It has to be a little more than that. It has to be on top of that. You're forced into a situation against your will ultimately, and then you feel trapped. This person makes you feel trapped. So there's a distinction there. The VAWA focuses on the mistreatment, focuses on establishing a qualifying relationship. The T visa focuses on what did they make you do that you didn't want to do. I applied for T visa and I did my fingerprint in April, but I haven't heard anything back. Yes, that's normal. You're probably not going to hear anything back until a decision or if they need more information. How long is the whole green card marriage based process? Could be under a year, up to a year. What can I do to get work permit? It just depends on your situation. This is where the appointment is going to be very important. Can you approve a travel permit before work permit in a VAWA case? Yes, absolutely, it happens. Yeah, I've seen that happen before. I already have I-130 in process with a US citizen. We're no longer together. Can I finish it with VAWA? No, no longer being together is different than are you being mistreated. If you were mistreated by the US citizen, then yes. And I would say it's urgent at this point for you to get the legal advice you need to make the switch from the I-130 process to the VAWA process. Now, another thing is, are you in the US? Are you outside of the US? Because that can also make a big difference. How much money do I have to have in order to petition for my mother? So they did raise the fees. If you go to USCIS and you look, and it depends on how many forms you have to file. Are you a US citizen? You have to file the I-485 form. You have to file the I-130 form at a minimum. So if your mom is here, maybe you want to even get her a work permit and a travel document. Go ahead and you can look up the fees there. There is a fee calculator on USCIS. Go ahead and do that because they've increased fees, and I myself am constantly having to look back at the fees to re-familiarize myself with the fees. Is it true that T visa applicants cannot check their cases at the USCIS? I have tried and says yes, absolutely normal. This is because of the confidentiality. They want to make sure that it's not compromised. Can someone adjust on a crewman's visa? She's married for 8 years now. No, unfortunately not. It is permissible under VAWA, but not through a spouse. What do I do? As you said, I should be concerned for my husband's case. I told you I filed and went for interview over 6 months, no answer. This is where it's very important to schedule an appointment. Can someone with a juvenile felony adjust status or qualify for new PIP if he qualifies for everything else? Now, with the PIP, they aren't very clear. So they aren't very clear yet on, let me know on Instagram if you can hear me. Um, they're not very clear yet on what kind of criminal conduct can get you disqualified from PIP. Let me know on Instagram. Can you hear me? I just got interrupted. So let me know. Yes. Okay, perfect. All right. So no, usually with a juvenile felony, it just depends on the facts here. Whenever it comes to criminal conduct or offenses, it really is something we have to take a very close look at. There are some exceptions when you're convicted under the age of 18, and we'd have to look at whether you fall within those exceptions. Thank you so much for letting me know. I'm glad that you can hear. Okay, awesome. All right, so I'm going to answer questions quickly here and then head out. And I wish you all a happy weekend, and I'll see you on Monday. I think I did pretty good this week, so let's keep this up. Why is it taking so much time for my baby's Canada visa to come out? So I'm not a Canadian attorney. You'd have to check with a Canadian attorney on that. The social security number and work permit come together with I-10 with German passport. So yes, so social security is issued separately, but they tend to come within a week or two of each other. So for example, I just checked with the mailroom and we got social security and the approval in the mail. They come from two separate places, but we just got them together today. So sometimes there's a week lag of the social security, and lately I've been seeing the social security number coming even before the work permit. So if you see your social security come before, you know that you've been approved for the work permit. What is permanent T visa? So there's no permanent T visa, but you can get permanent residence with the T visa. That means you can get your green card through the T visa. How long it's going to take me in having my green card, which was invited by my wife, who's a green card holder. If you're outside of the US, you're looking at about 2 years. Please, do you have any office in Maryland? We are based in Florida. We service clients all around the country, and I have a number of clients in Maryland. So it doesn't matter where you are. We can help you. Just call that number. If I overstayed my visa, how can I get a green card? Now that that's where we have to talk to you about your circumstances to figure out a path to the green card. But that's going to depend on, what we find out in that consultation. Can a family member here apply for temporary guardianship of 5-year-old whose guardian in Jamaica is no longer able to keep her? So it's not going to be that easy. Guardianship does not entitle anybody to immigration status. You're probably going to have to go through an adoption process to be able to take the 5-year-old under your wing to care for them. But guardianship is not going to fulfill the requirements to get them here and get them under your guardianship. If came to the US on farm work and didn't go back to my home country, can I get a work permit? No, not automatically, but you may qualify for a work permit through other relief, and that's where we need to figure out what your circumstances are. When you get your VAWA approved, it just depends. I'd say 2.5 years to get the VAWA approved, 2.5 to 3 years. If you want to apply for a waiver, what do you do? It depends. Now, usually they'll have to tell you. In some cases, for example, when we're applying for adjustment of status, if we know right off the bat our client needs to apply for a waiver, we can apply for it at the same time as adjustment of status. Sometimes, for example, when you go to the interview at the embassy in your country, they'll tell you it's time to apply for a waiver. Does someone have to file with the Vermont field office when filing I-485, or can you file at different office? So the Vermont Service Center does VAWA, TUs. So it depends on what kind of application you're filing. There's very specific instructions on where to file your I-485 depending on the application type. But this is where, guys, it's very important to just have representation so you're not making any errors on where your application needs to go. I meant to say I sent in my RFE February 2024, and in March of 20 is the last update I've gotten. So yeah, it's a waiting game right now. Can my 17-year-old file for me when he reaches 21? Does he have to be employed? Yes, he can file for you when he reaches 21. Does he have to be employed? Not necessarily, but you do have to have someone who can step in to show they make sufficient income to get you the green card to support you. If your mom is a green card holder about to be, okay, and I answer that. All right. Thanks again, everyone, for your time. I really appreciate it. It's time for me to get back to work. Have a great weekend. And I will see you on Monday. Just take it easy. And remember, you want personalized legal advice, you want to figure out how to move forward. That's where I'm going to lean on you, depend on you to get in touch with us. We are open to take calls 24/7, 7 days a week, right? So we have a whole call team that's open to take your calls. So go ahead and enter your call. And then also, there's this nifty little thing on TikTok. I'm going to go ahead, a form, fill out that form, and I will go ahead and collect your information, your contact information, and we'll call you. So you have 20 seconds to enter it on TikTok. It's not on YouTube, Facebook, or on Instagram. I wish I'd have something like that. But on TikTok, it's right there. I put it up there now. Go ahead, enter your information. I'll do it again. So you can enter your information and we'll give you a call back and schedule your appointment. I'll put it up again on TikTok. All right. So now another thing I'm doing is on YouTube. I am releasing videos, informative videos that explains the processes, anything that's going on in immigration. Check me out. I'm getting the green card, all one word, no spaces. Getting the green card. That's the YouTube channel. And the videos help you to understand. For example, I just released one on the prima facie. So go ahead, the prima facie determination letter that's issued when you are applying for VAWA. So that's one. And then if you want, you can always DM me on any of the platforms to give me ideas about what you want to hear about in detail in these videos. The videos range between 5 to 15 minutes regarding a specific topic. All right, so check me out on Getting the Green Card on YouTube, and I'll see you on Monday. Have a great one. Bye bye.